we had like a special process server several times like give us this report that this guy was in there, that he was sort of around at night and was like purposely avoiding him, and of course the sheriff went out there, tried a few times, prior to that, and yeah, Gomlinski was like, I'm not going to do that, like you guys have to, try harder with special process server before I can let you, effectuate service that way, so who knows.
Plus I'm looking for a family law lawyer to go out and keep one of our, we have a house that went up and the kid jumped and he's got $200,000 worth of medical expenses because it went up.
Okay.
And
right.
Suddenly the father's interested in having custody.
Of course. He's a minor, I take it? Yeah.
Yeah.
Right.
So I got to find some family law lawyer to go down there. I mean, I just mind going down there on a family. There's a lot of procedure that's involved.
Yeah, no, the people across the hall from Hofeld and Schaffner, they're a family law firm, and I had a friend who had a friend who needed just a straight divorce. Again, I didn't know anything about that. I mean, it's like medicine.
Never want to. It's terrible.
Yeah, so I pulled up the paperwork, and I'm like, I could probably just do this for her, and I'm like, you know what? I'm just gonna ask one of these guys down here to give her a call because I don't know and I don't want to screw it up.
But we know who's gonna pay for it.
Right.
And that doesn't make me real happy.
Sure.
Of who I am and whatever. Okay. I mean,
Yeah, it's everything is overly overly technical. Maybe overly technical.
It is.
Yeah.
If you're, it's like a lot of things.
Right.
If you're just a mope, you're going to get screwed if you're up against an attorney.
Right. No question about it. Yeah.
The guy on the other side's got an attorney.
Right.
And I bet you I know what he's looking for.
Sure.
So anyway, well, whenever you're ready, babe.
Yep.
Well, we first of all, thanks for coming back. I mean, you're one of the few candidates that
my pleasure.
That actually said they didn't want to come back.
Well, it wasn't necessarily that. It just was my lack of understanding, and I don't pretend to understand your practice. It's just like we were just talking about a second ago. Anything you do, is so specified, and to be good at it and to have a thorough understanding of not only the legal aspect of it, but the business practice of it, it takes a lot, you know what I mean? And I wouldn't expect to completely understand. And I maybe jumped to some conclusions or made some assumptions that were incorrect, as I said, and I certainly appreciate your message. I just, it all sounded great, and I, was, advocating, and I think, man, this is a great cause, and I totally understand at least what you're trying to accomplish. There just was some holes in there as far as just the business of it. And again, that's not even really my concern. It just was sort of.
No, and you do raise a few issues in that, so that was good. Just note two things. One, if you have a feel for where we are in the grand scheme of thing of the market. I mean, recently we've had some good news with the federal government, putting some funds in the market. So, the S&P is at a record high. We think that's going to dissipate to the harsh realities, and the next leg of the bear market is going to come and take hold all the way to the end of 2016.
Okay.
So it's premised on the fact that we're due for the next wave of foreclosures.
I'll let my dad know about that.
So when you talk about...
with the market, I mean, you know what I mean? Yeah.
So when you think of a foreclosure practice,
Right.
I mean, there's lots of things that go in your mind. But
Right.
From our perspective, we think this is a really good practice area. I mean,
Sure.
from one... And what I like best about it, it's predictable. You know that you're going to get a handful of clients coming in every month. You don't have to worry about, is someone going to respond to our personal injury ad or
Sure.
whatever else. So that serves as, a nice cash cow coming in that we don't have to worry that, our lights are going to be paid for.
Right, and that is extremely important. Yeah, I never thought of it like that.
So that enables you then to do the fun cases.
Right.
Like PI and the things that you've been doing at Schaffner. And I'd like to think the fun cases we happen to have in foreclosure defense.
Right.
Which are, marquee cases because people are coming to us specifically because of Ted's early win in 2011.
Okay.
So of all the foreclosure cases that are out there, we're tending to get the really good ones.
Right.
Where there are really important defects that, have, clear ramifications.
Yeah, I thought it was interesting too, the case where it was a commercial lease or commercial mortgage or however that was, and they literally sort of told them to, we can't talk until you default on your loan, and so they did so in sort of reliance upon that, and then once they did, they're in this precarious situation again with regard to the standing and the proper party and all that. So, no, it's certainly, the more I know about it, and the more I read things and read the cases that are on point and sort of delve into it, the more I understand what's going on. And it's it's a head scratcher at times, because you're like, how are they not seeing this? I mean, those briefs that you guys wrote, in my opinion, my humble opinion, certainly, they couldn't have been better. I mean, it looks like, what about this are you not reading and not understanding? So maybe
we should spend money and make him a judge.
Yeah, right. Well, yeah, absolutely. I mean, it's like they're finding a way to do what they don't want to do. And so it's like they're saying, for whatever reason, your argument's great, but we're going to find this little tidbit of information or any, little bit of support, no matter how overwhelming your support might be the other way, that says, no, they are the proper party to bring this foreclosure.
And it's tough for you.
Right. No doubt about it. And
it's tough for you because you're going to stand up there and you're going to make great arguments.
Right.
And you're going to lose. I have the 3N argument. We have an early standing argument. I'll tell you all about it later if you're with me. But we have lost that argument in numerous times.
Okay.
We won it for the first time out in DuPage in front of Gibson. Then we won it up in McHenry. And 2 days ago, we won it for the first time downtown.
Phenomenal.
So, yeah, but I mean, we must have lost it 25 times.
Sure, like anything, right.
And it's how you replayed it. So anyway, we're glad you're back. And what we wanted to do, if you see all the high tech, don't let that scare you. John Miller, who's Ted's other partner, is in Europe.
Okay.
And so what we've done, and for some of the candidates, is just record their comments about the Bassman case, and you've done your write-up. So we just wanted to hear your short verbal take on the case and what you thought of it and what you proposed to how to advance the securitization argument.
Right.
Then we're going to turn that off and then just talk between us kids and what some things that might be of interest to us. So
Sure.
Why don't we start there? Let's talk about your take on Bassman. We both read your write-up, which was good. I thought you had an interesting take on it, but kind of give us the highlights, and then we'll go from there.
Sure. Well, like any of these, they're easily identified as not the proper part, not the party with proper standing. But I think the problem is trying to use something to claw back at the party who does have the proper standing. And when it regards anything relating to trust, that becomes increasingly difficult because, as like Law School 101, trusts can basically do whatever they want, outside of being illegal. And so when you're sort of saying that this trust language between, two parties, you're the third party, between these two parties is allowing us or disallows them from doing what they want to do themselves, it's just a bad place to sort of guise that argument, in my opinion, because they're going to say, this is our trust, whatever we do or don't do, or, long story short, if it's for the benefit of the beneficiaries, it's going to be okay. And that language was probably archaically put in there, the statute that is, to disallow trustees from doing something that the beneficiaries and the trust didn't want them to do. If for whatever reason what they do, although technically wrong, is found to be okay by the powers that be, it's okay. And so
even in the case of a REMIC trust that has tax implications that would actually charge the beneficiaries 100% on the dollar because they violated the REMIC provisions?
Well, that's, admittedly that's a area of the law I'm not that familiar with. So just generally speaking, that's kind of how I felt like the court used. That's the ammunition they used to find the way they did.
Right.
They found some case law that I read cases. They clearly, the trustee did something outside of the trust language, and the beneficiaries ratified it or said it was okay or didn't cry foul, and they said, okay, no big deal. That case law is out there, and they had it, and they can use it. There's case law to the opposite that says the trustee did something that was outside the trust language, and therefore the transaction or whatever they did was void. Again, it comes down to the court. If it's available for them to find against a third party trying to implicate a trust language, to benefit that third party, they're going to do it. And that language is out there, or the cases are out there. So I think that's the inherent problem in investment cases because, and again, I don't know about these REMIC trusts and the implications of that, tax dollars or how that they function, but just thinking of trust generally, that's sort of a hard place to...
Now, it's interesting you say that because our view is because people don't know what those tax implications are.
Right.
The law clerks of the judge who gave the ruling and the judge herself.
Sure.
Is it your opinion that what would be needed is someone who's very familiar with New York trust law and these REMIC provisions that can get their arms around to articulate the subtle difference to advance the securitization argument?
I think that would help. I mean, certainly, anytime you have something that is, not your run-of-the-mill trust document where it's saying this is for us too and the language is what it is, if there is, like, implications to, society at large, obviously when you talk about these REMIC trusts and they're just compiling all these mortgages, I feel like that affects society at large. Certainly, someone who's well-versed in that and could tell you specifically estates and trust law is technical like anything else, and especially trust law, and how it functions and sort of like anyone's, rights under the trust. But, if you had someone who really, really knew about that, that would certainly help. I don't pretend to. I certainly could educate myself, but...
Is that an area of interest for you?
Absolutely. I mean, for me, it's always about just finding the tool to get the job done. And so if you have to, making creative arguments is something I certainly enjoy, and if that is an area where you're not so, savvy, then explore it and understand, the technicalities that would allow you to put that argument, in front of a judge. Because the way I saw the defendants there arguing, it was just the fact that they said they didn't do what their trust document said they were supposed to do, and the court said, well, look, nobody who actually is has a right or a duty under this trust had a problem with it. So it's not your place to say whether they did or did not do anything correctly. And I think, again, that section that they applied was written long ago and been applied in sort of inconsistent ways that allowed them to sort of find the way they wanted to find.
Now, in your write-up, you said a review of the Illinois trust law did not reveal a similar provision to 7.2.4. Did you look at the Illinois trust law?
I did. I mean, I didn't read the entire code word for word, but I did I looked at it, certainly, and I didn't see anything. Now,
did it surprise you that there was nothing similar?
No. I thought that was probably more correct, because trusts are created, by the trust creates the trust in the sense that whatever language that they want to put in there, whether they want to make a transaction void or voidable, or if the trustee can act outside the scope and has to be ratified, or he just flat out can't do it. If he does one little thing that's not allowed for, then it's, not okay. I think that makes more sense with trust law, generally speaking. The trust is a very specific thing, and to the letter of the trust, that's how everyone under it should act. And so that made more sense to me than to have some statutory language saying anything about how a trustee is to conduct himself as the trustee.
One of the things that big firms have done for years and years and years is that they'll just get killed by the Illinois Supreme Court or the Seventh Circuit or the U.S. Supreme Court.
Sure.
And they just get murdered. And they'll go back and they'll sit down and they'll start looking at it and they'll start picking at it and do what John and I call parsing. Take a little area and say, well, Judge carved this one out.
Sure.
And 4 or 5 of them will be in there arguing the same thing in different parts of the country, and then they'll get a little bit there, and then they'll add that and try and parse that down. Here, it seemed that she just was angry that the defendant hadn't come up and given her the law that she was looking for.
I agree with that too. There was a lot of sort of, basic like choice of law. I mean, that's a pretty obvious and, simple area of the law to understand, and she had to, sort of speak about that, and that very well may be that they, that she thought that, through her research, this is the conclusion she came to, but that doesn't mean it was the gambit of it. And
Yeah, Austin and I have talked about this.
Well, she revealed in
she
her.
didn't, it was some damn.
If you read that opinion very close, there's one telling sentence near the end that said, "I just can't believe that the architects would have allowed a homeowner or a commercial lender to come back and challenge this." And so that was her predisposition.
right, I totally thought that it was. I mean,
So
was,
she already had her position. Right. She was looking for a way to rule on that. So, but that's interesting that you're saying that. Any other things that you would like to disclose with respect to how we might attack it going forward in state court?
Well, and again, I don't know the practice of foreclosure defense that well, so maybe this has all been tried, but to me it seems like you have to
new.
Right, you have to give courts sort of a reason, you know what I mean, and just sort of, and what I mean is, when a homeowner has certain rights, I would imagine, when they enter into a mortgage whereby they have, they can pay it full. We talked about all the remedies, and that language is in there in the original mortgage for a reason. It's to allow them to have some sort of rights whereby it's not just like the first time they don't make a payment, default, you're out, and you're on your ass in 30 days because you didn't make one payment. Life happens, things happen, and so they build these remedies in there. There's a reason for them, and there's a reason why. And so if you can evidence why they're in there, you might allow a court to sort of, okay, now these homeowners are being robbed of their sort of rights under this, arm's length transaction, and so maybe there is a reason to challenge standing for this particular plaintiff because they're not allowing them to exercise these rights. I think that's the most important thing. Now, how do you evidence that? You would have to bring some sort of legal vehicle to get to that information, because obviously any plaintiff, in that scenario is going to say, no, that's just our language. We did it because we felt it was, something to benefit us, then give you a line of crap, and that is what it is. But I firmly believe that language is in there for homeowners, and those are, inalienable rights that they have, and they should be able to have to go through that, or before they foreclose, they should have to prove to the court that they've done all these things. We tried to negotiate. We allowed them, we sent 4 or 5 letters allowing them to pay. And something to evidence that they've done what they have to do, and allowed the homeowner to rectify it in any way that the document allows.
As you can appreciate, over the life of the legal issue, there's popular defenses, affirmative defenses. Securitization fail really started in 2010.
Right.
It took a life of its own, and now Bassman was kind of so there's one group of people that are just backing off of it completely. Some are saying, well, she didn't address it, so they're going to advance it. What I like what you did was, thinking outside the box, how else can we attack the matters of first impression?
Right.
Because at the end of the day, what we're looking for are creative ways. If there are new affirmative defenses we haven't thought out, and that can be crafted, all in the spirit of keeping the homeowner's rights protected
right.
and alive, that's what we want to do. Quick question: did you hear the Nick Wooten piece? The podcast.
Yes, I did.
And the Alabama lawyer with the deep accent.
I don't think I get that one to play.
Okay.
I watched the other one. There was one like a CNBC thing. Was that you might have sent to me? Sent me that before.
Okay.
But I don't believe that one. I don't remember the Alabama accent.
Yeah. Well, then you probably didn't get the. You probably the link didn't work in any way.
Right. I read there's kind of like an article about that Alabama decision. Was that related to that?
Yeah, that's.
Yeah, but he's worth the price. He's an interest. When you hear
sure.
these guys talk, it's like Southern lawyers, Southern country lawyers,
right?
Western country lawyers.
Okay. Different
breed.
I would imagine.
And this guy just drips passion.
Well, he's what I call a warrior lawyer, and there's very few of them. And we were hoping that the next person we brought on board had the predisposition of being that kind of warrior lawyer. So.
Certainly. And to that effect, I guess through all this, I had a question too. When you think about the ultimate goal, I mean, obviously challenging standing is going to, isn't that just to put the proper plaintiff in a court where they can sort of be forced to allow the homeowners these remedies or give them the opportunity to negotiate?
Yes, and yes, except that the original lender
is long gone.
Right. So a part of this, at least among our adversarial borrowers,
right,
is only because they've been screwed around for the last couple of years, and they just want to make sure that there's some justice in the process. Now, whether that's gets us down a moral slippery slope, that's for them to decide.
Right. Yeah. No
but
there.
With respect to what we're doing, we almost backed into the practice, partly because of Ted's early success. I mean, we've gotten a lot of cases that probably we wouldn't have had if it wasn't for that. Right. So,
yeah, there's two thoughts here. First thought is exactly down that line. Okay, they're going to have to back off and start all over again.
Right.
For our clients, that's a really big deal.
It just is like a sort of feel-good thing, or like just to be in the position
for us, it's not all that good when we win there because the client's going to stop paying. He's not under any.
Right.
Okay, but for us, we've won. Because a huge amount of this is to take people who went into foreclosure because, remember, the economy tanked as well as housing prices tanked. And huge numbers of people lost jobs.
Right.
Or their other person whose income they needed to make this lost jobs, or they went from, being there full-time to 8 hours a week instead of 8 hours a day.
Sure.
So they're down huge and they don't have the money. Jobs are starting to come back. Incomes are starting to come back. We're starting to see mortgage companies, not all that often, but fairly often, offer people the opportunity to come back in at a mortgage for 80% of the fair market value.
Right. I would imagine, at some point in time, it would be in their best interest just to sort of renegotiate these clearly underwater, loans.
Some of them are coming to that conclusion, and because they don't want any more of these goddamn properties in Illinois.
What am I going to do with another house?
I just saw numbers this morning that they're going to increase. They've gone from 28% to 33% of the mortgages in Illinois are now underwater, and pretty recent. So we have that, and for them, that's what they want. They want you to hold on for them during a period of time where they're getting another job, and they're excited about that.
Okay. Because that's what I was thinking too. I mean, you get these, vehicles, these trusts where they just have a glut of mortgages. They have no incentive other than just to foreclose and sell all the property and make as much money today and right now as we possibly can, or however they, I don't know about that.
No, it's just fixing their loss.
Right.
And we have seen forever in company after company across America that it's important for them to determine what their loss is, so that they can tell their shareholders, and so that they know, and they don't have accountants like this guy used to be telling them, well, we're going to have to give you a qualified opinion until you can come up with some numbers here.
Right. That's even like in the personal injury field where, the insurance underwriter just wants to know if you give high lows for, settlements. It's like, if we know, I don't even care if it's $20 million, as long as we know what our risk is.
And so what you want to do is put the client in a position where they can do that.
Right.
Second point is if you do something like we did in Bosanowski, and the court determines that the plaintiff's case is dismissed with prejudice, without prejudice for anybody else to bring it, which is exactly the language she wrote, so that these people, this trust, could no longer bring that case, okay? But, somebody else could bring that case.
Right.
Well, they're going to have one hell of a time trying to buy from somebody who has had their lawsuit dismissed with prejudice, okay? Anyway, but, it's money. Somebody will pay 3 cents on the dollar and take a chance. All of those things are what drives these folks to say, shit, I want to get involved. And like I said in my note, the the idea is we'll do it by the month.
Right.
We have a lot of people who do it on a flat fee up front. Well, you know, if you're at $750 a month, you don't have to do the math too hard to figure
Right.
out that that's $9,000 a year, most of these people.